Please, Your Lordship, I beg to mention item number 17. Conducting counsel is on leave, is on sanction leave.
Yes,
so I pray for 1 week.
You are for?
For the petitioner. 1 week.
Lordship, we are for the respondents.
1 week, Your Lordship.
On premiere by the petitioner, list this matter up to 1 week.
Highly obliged, Your Lordship.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 9. I'm on behalf of the petitioner, Your Lordship. Item number 9. Your
Yes,
Lordship.
what is your prayer?
The conducting counsel, he's on leave, Your Lordship.
How long?
After 2 weeks, Your Lordship.
No objection, Your Lordship.
On premiere by the petitioner, not objected to by respondent. List this matter up to 2 weeks.
Deeply obliged, Your Lordship. Wait, please, Your Lordship. I beg to mention item number 12, Your Lordship. Your Lordship, here we have received instruction with regard to the survey report filed by the respondent. If I may be allowed 1 week time, Your Lordship.
2016 matter.
Your Lordship, we have just received the instruction from our clients.
1 week.
1 week, Your Lordship.
On premiere by the petitioner, list this matter up to 1 week.
Much obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 20, my lord. If this matter may come up after 3 weeks, my lord. 20.
No.
On premiere by the respondent, not objected to by petitioner. List this matter up to 3 weeks.
Much obliged.
Obliged.
Please, Lordship. Lordship, I beg to mention item 5, Lordship. Oh. Item 5, Lordship.
Yes.
I pray the matter may come up so weak, Lordship. The conducting counsel is out of station.
Part-heard matter.
Oh yes, part of it.
It's all right, man.
By the time we keep adjourning the matter from time to time, the purpose of having parhat, will lose its, its value in as much as you have to again start your argument afresh.
May it please Your Lordship, I'm appearing for respondent number 6 in this matter, Lordship. I'll have to see whether I can still appear or not, Lordship, in view of the new developments, because the state is involved in this matter also, and I'm also respondent number 6 over here.
You take your instructions
Lordship,
and take necessary steps.
will do, my lord.
On premiere by the petitioner, list this matter up to 2 weeks.
Much obliged, Lordship.
Lordship, similar prayer for item 18, Your Lordship.
Item?
Item 18.
No objection, Your Lordship.
On premiere by petitioner, list this matter up to 2 weeks.
No objection. May it please Your Lordship, I beg to make a mention on item number 10.
Item?
10.
Lordship, I'm for the respondent number 4. 2015.
This is also a part-heard matter, isn't it?
Yes, Your Lordship.
With regard to that
Revenue plan.
revenue.
Not only.
Lordship,
Cannot
1
keep,
week's time may be
cannot
granted.
keep adjourning this matter like this. 2015 matter. Fine. We'll hear the matter tomorrow.
1 week, Your Lordship.
On premiere by the petitioner, list this matter up to 1 week. it is however made clear that no further adjournment will be allowed.
I'll leave back.
Similar prayer for item 14, Your Lordship.
Not 2 weeks though.
Item 14.
This is also an old matter.
Lordship can
You are for?
the petitioner, Your Lordship.
Who is for respondent?
GCDC, Your Lordship.
Let it be called up.
Will you oblige, Your Lordship?
May it please Your Lordship. Your Lordship, I beg to mention item number 19. The talks are still going on among the parties, Your Lordship, for settlement. So kindly allow us some more time. Item 19.
You are for?
Respondents.
And I'm appearing on behalf of the petitioner, my lord.
Is there a serious effort made to settle the matter?
Yes, my lord. The process is still going on, my lord.
Parties have submitted that the talk for settlement of the matter is still going on, and as such has sought for further accommodation in this matter. On pre-meet, place this matter to 2 weeks.
Please, Your Lordship.
Supplementary cause list, item number 1.
May I please, Your Lordship? This bail application filed under 438, my lord, for anticipatory bail, my lord. My lord, on the basis of the FIR, my lord, the FIR was filed on 18/6/2022 by Shri Mofuzul Haq, alleging that there is a theft, there is a dacoity in his residence, and rupees 10,000 and 10,000 amount of ornament in the form of gold and silver was stolen by the alleged accused. And on the basis of the FIR, the police has registered a case, case being Fulbari PS case number 48 in bracket 6 of 2022 under section 397, 395 and 34 IPC. And during investigation, one accused was arrested from Khetadhua village. And the brief facts of this case is that, my lord, the accused is owned one car, Swift Desire car, and allegedly his car was used in the commission of the offence. The driver, the accused having one driver, Samiul Islam, he and the car was used in the commission of the offence. But the accused person was not in the place of the occurrence, was not even in his residence on the day of occurrence of the offence. He is in the Gwalpara, my lord. On 17, the driver himself, he's taken the accused, taken the accused Sri so-and-so to the Gwalpara. So after that, my lord, the two accused has disclosed in their statement, my lord, after arrest, that the involvement of the accused. Thereafter, the police is apprehending the arrest of the accused. The accused has moved 2 times bail in the district court, but the district court has rejected the bail application. Hence, this bail petition before your lordship. At least the case diary may be called, at least, my lord. The status of the case.
This a case of pre-arrest bail or?
Pre-arrest bail, my lord. He is still apprehending arrest, my lord.
When was the FIR filed?
FIR is filed on 18/6/2022, my lord.
How long now? It's almost.
My lord, yes, my lord. Now,
9 months or even 10 months?
My lord, yes, my lord.
Where's the apprehension?
My lord, there is still, he's doing his business, my lord, through like hire this car, using his car.
We are not talking about the facts of the case.
My lord.
That would come in due course.
Yes, my lord.
In course of evidence or investigation.
Yes, my lord.
Then if there is any evidence against you, of course. But as of now,
My lord,
if there is
still
no-
there is apprehension, my lord. Sometimes police comes to his residence for arrest and all, so there is still apprehension, my lord. So therefore, I humbly pray before your lordship, at least case diary may be called. So the status of the case may be, at least, my lord.
The statement made by the counsel for the petitioner, lordship, he stated that the police come to the home of the petitioner. It appears he's evading arrest, number one. Number two, lordship, the application is incomplete. Over here, they've stated over here that the rejection order was not uploaded by the concerned court. As such, the petitioner could not index the rejection order. Lordship, we do not know on what basis the bail application was rejected, lordship. They cannot come with a status that it's been rejected, lordship.
in any case, that is not impugned.
Lordship, not impugned, lordship, but nevertheless, lordship, the period as rightly brought forth by this honorable court, 10 months, lordship. Where's the apprehension of arrest?
My lord, one order we have annexed, my lord. Another order, the last order, we could not annex, my lord, because the order is not uploaded, and we have.
They could have applied for a copy, my lord.
Yes, my lord. We have talked to the lawyers concerned, but there is, because of their discrepancies in their part, could not get the certified copy, Your Honor.
It's been 4 months, my lord.
Yes, my lord. There is a delay, my lord. 4 months of delay, but we somehow we.
Anyway, you've produced the CD.
Lordship.
How soon?
1 week, lordship, because it's Tura.
Heard S.K. Hassan, learned counsel for the petitioner. Also heard Miss Angela, learned your senior
Government advocate, lordship.
senior GA. Before proceeding with this matter, as submitted by the parties, the case diary is required to be produced for this court, so as to know the present status of investigation. Accordingly, the prosecution is directed to produce the case diary of Pulbari PS case number 48-6 of 2022 before this court on the next date fix. In the meantime, the petitioner is allowed to go on interim bail on condition that he shall not abscond and that he shall cooperate with the investigation as and when required. The interim bail will continue till further orders. This is matter after 1 week.
Much obliged, lordship.
My lord, highly obliged.
May I please, your lordship? Before I start my submission before your lordship, I would pray your lordship for a small typical correction. The name of the petitioner number 1, lordship, has been wrongly written as Angu Shuman. It is Ong Shuman, lordship. You may kindly be ANGU. U has been wrongly typed, lordship. Page number 2 in the cost letter, lordship. Lordship, here the facts of this case draw your lordship's attention. Lordship's attention to the FIR, which the lordship will kindly find in Annexure 1, page number 18. A small FIR, but the FIR speaks of certain things, lordship, which unfortunately have been alleged to have happened on 21/1/2023, when all these informant as well as the petitioners, they met in a rally, motorcycle rally, lordship, and it says that there was an attempt for murder. Now it very clearly says that he have received an assault in his hand, whereby he subsequently came to know that his hand is broken. Now my submission before your lordship is this, that this story does not reflect or does not brings any confidence. Reason behind this, lordship, this informant as well as the accused, they all hail from Silchar, lordship, and the incident took place at Umiam. Now, the distance between Umiam and Silchar is around 299 kilometers. A person, if he has sustained some injury in his hand, he cannot drive back his motorbike again to Silchar, because what has happened after the incident has taken place, the organizer said that no, because of you people, the function is being foiled, so please leave. So this informant, he took his motorbike, drove his motorbike, and he went to his residence at Silchar. And after that, when he made an X-ray, he found that his hand is fractured. And that is altogether the case. Your Lordship will kindly see, here are 5 petitioners, Lordship. The petitioner number 4 and 5, Lordship, have been arrested on 24/3/2023, and they are still behind the bar for a period of around, today is 25 days, Lordship. And petitioner number 1, 2 and 3, very interestingly, Lordship, they were first given the anticipatory bail. They filed an anticipatory bail before the session court. They comply with the order. They appear before the IO. Subsequently, when there was a hearing on that bail petition, as per 438 subclause B, their presence was required, and on that day they were taken in custody. It was 30/3/2023. For 18 days they are behind the bar. So the forwarding report is there. Lordship will kindly find the forwarding report in annexure number 19 and 21, page number 19 and 21. It clearly says, Lordship, my submission before Lordship is this, that there was a conflict going on between them since long. All of them, they belong to a common club, and the informant was in fact suspended from the club because of his anti-club activities. Because of that, there was some sort of conflict going on between them, and they happened to meet for the first time after this conflict on 21/3. Now, if your Lordship may kindly appreciate that a person, if he has sustained injury in his hand, he will go first to any doctor, nearby doctor. There are a lot of doctors nearby. I should have come down to Shillong. Shillong is also not so far away. Going to Silchar, that also riding a bike of 299 kilometers, cast a serious doubt on the very story that he has projected. Lordship will kindly see
that would depend on the stage of on the progress of investigation.
Yes.
And the medical report, of course.
And then Lordship will also kindly see that Lordship is absolutely correct. There is a delay in lodging of the FIR. That FIR was, your Lordship, the incident happened, if your Lordship kindly have a look, incident happened on, allegedly happened, whatever he has alleged, that is on 21/1/2023, and the FIR has been lodged on 26/1/2023, after a delay of about 5 days. So it casts a serious doubt. I would pray if Lordship may kindly call for the case record. Now, if it can be kindly called, Lordship, on 20.
Yes, tell me.
Lordship, at the interim stage, the bail applications have been rejected. So at this stage, I pray that CD may be allowed to be called for.
Yes, that will be called.
Lordship.
I am praying for if it can be fixed on 20, Lordship.
Lordship, Monday, my lord.
Monday will be little bit difficult.
Monday will be
24th.
24th, my lord.
Then let it be on 26, Lordship.
26.
26. So for the second matter is concerned, it is arising out of the same FIR. But here, Lordship, I would pray that here the case diary, if possible, can be kindly be called on 20, Lordship. Because, Lordship, his festival is there on 22. It's the same incident.
How can you assume that he may be released?
Lordship, his health condition is very bad, Lordship. He is still in medical, Lordship.
Have you have come? Let me pass on order first.
Yes,
in this case.
yes.
But there are counsel for the petitioner.
One by one,
But Mr. counsel for the petitioner also. But Ms. Sheila Leonard, senior GA, appearing for the state respondent. Before proceeding with the merits of the matter, the counsels have submitted that the case diary of Umyam PS case number 4/1/2023 may be called for by this court so as to know the status of the case and the complicity of the accused therein. Accordingly, as prayed for, the CD of said Umyam PS case numbers so and so be produced for this court on the next date fix. Prosecution is directed to take steps accordingly. As submitted by the parties, place this matter on 26.
Much obliged, Lordship.
So far as the second item is concerned, Lordship, it is also arising out of the same FIR. In fact, the other petitioners were not named, but he is the only one.
So, Mr.
Lordship, I am praying, Lordship, he is very sick, Lordship. If he can kindly be granted
20th, produce the CD on 20th.
Diplomat.
Same order? I know, CD on 20th.
Item number 4.
I cannot see TP.
We'll take it at the end of the board. We'll take it take up at the end of the board. I think the other counsel for the other respondents is not here.
Leading causeless, item number 1.
May it please your lordship.
Yes.
Lordship, may kindly recall this is that legal aid matter where writ petition was dismissed 13 years back.
13.
We are attempting to restore it. They have filed their reply against my condemnation petition. If they are ready, we can take up the condemnation.
Yes.
Shall we take next week, sir?
Ask.
My lord, may this matter may come up after 1 week, my lord.
Is this a case of a termination? Or?
Termination without notice, my lord, without DP being conducted.
So practically he's out of service for the last 13 years. Or
13 years, my lord. So even if it is restored, lordship may have to mold the relief that we had originally sought, because I don't think he's in a condition to rejoin the service. But
what is his age as of now, as on date?
Lordship. Lordship, I apologize. My copy is blank, but it should be there in Lordship's copy, the affidavit.
Do we still have to go to our primary school level to fill in the blanks?
Lordship, I have to, my lord. I apologize. Page 11, my lord.
$43 years.
43 years.
On prayer made by the respondent, list this matter for 1 week.
Obliged.
Item number 3.
Yes,
the petitioner was supposed to take steps on the evidence.
Just file my power today. If this matter is taken up,
Land Council, Mr. Land Council has submitted that he is entering appearance on behalf of the respondents 3 to 6 respectively. Have you filed your power?
yes.
And has sought for some time to be heard in this matter. How long? As prayed for, this matter for hearing after 1 week.
Item number 4.
Yeah, please, Your Lordship. Your Lordship, this is the case where the FIR has been lodged for the violations of a status quo order arose out of a civil case. So the complainant is very much present out here.
I appear
You are
for
for
respondent number 2.
Respondent 2.
Yes, my lord. As a matter of fact, this is my first appearance, my lord. If your lordship can fix it next week, my lord. Here in this matter, my lord, we have already settled the issues between us. The proceeding which is pending before the trial court, my lord, so far as the other sections in IPC are concerned, that has been dropped. Only one section is there, my lord, which is 188. The court said it doesn't have powers since it's non-compoundable. But the fact of the matter remains, my lord, 188 in this matter, my lord, could not even have been invoked.
Whatever the case may be, since you say that you have settled the matter,
Yes, your lordship.
have you filed any settlement?
Your lordship may
deed
kindly
or
grant us some
compromise?
days time. We will file the settlement report, my lord.
That would be easier.
As your lordship, please.
that would come in a form of a compromise, which would allow this court to compound any case which is non-compoundable. Mr. Estafa has entered appearance on behalf of the respondent 2 and has submitted that he may be heard on the next date fix, as he is not prepared for this hearing today. However, it is also submitted by the learned counsel that the matter between the petitioner and the respondent number 2 has already been settled amicably amongst them, and for which some time may be allowed for a formal deed of settlement or compromise to be filed for this court. On consideration of the prayer made, the same is allowed. Let steps be taken accordingly. The deed of compromise or settlement will be filed by way of an affidavit. As prayed for, this is matter after 1 week?
1 week.
1 week.
2 weeks.
Why?
Next week I may be out of the station, so let it come after 2 weeks.
Your colleague is there.
Yeah, no problem. Let 1 week.
This is matter 1 week.
All right.
Item number 6.
Lordship,
yes.
In this matter, we are in the process of filing the for amending the prayer, Your Lordship.
Have you filed?
We are in the process of filing, Your Lordship. So, Lordship, I pray this is matter up to 1 week.
Learned counsel for the petitioner has submitted that you have not filed. First, you have to file the application for amendment. That has not yet been done.
We are in the process of filing, Your Lordship.
The application for amendment of the petition could not be filed earlier, but the same is in the process of being filed in the course of the day, and as such, some time is sought for this matter to be heard on the said application. On premium, this is matter to 1 week.
Item 7 connected matter, Lordship. Item 7 also connected matter. Lordship, similar prayer for item 8.
Item
8 connected, Your Lordship.
All connected. 6, 7, 8 connected.
Yes, Your Lordship. But
you are also filing application and all.
For amending only item 6 and 7, Your Lordship.
Only 6 and 7. And 8?
8 is not required, Lordship. Only 6 and 7.
So we'll hear item 8.
Lordship, senior counsel is out of station, Your Lordship.
6 and 7. 8. Submission has been made on behalf of the petitioner seeking adjournment on the ground that the senior counsel who is conducting the case is indisposed. Prayer not being objected to by the respondent, seems allowed. This is matter to 1 week.
And you oblige.
Item number 11.
Lordship, there are two connected matters in this item. Lordship, I'm appearing in CRP 21, 2016. Lordship, in the other CRP matter, Mr. Gautam.
Yes, who's appearing?
It's not available today.
Which is the lead case here? Or they are
leading case?
Is it 22 or 21?
Because it's arising out of the same order, Lordship.
Same order. But why two petitioners?
Should the response? There is.
Yes, Dr. Musika, you are appearing?
Madam, there are two revision, my lord, against the same order. One is filed by the State Sports Council, my lord, which is an autonomous body under the state government, and one is filed by the state government, sports department, but against the same order.
Against the same order, on the same ground.
Same grounds, more or less.
Why?
Both were dependents, my lord, because SSC is a sort of private body, my lord. That's why.
Who is appearing for the respondent?
Which is the first matter. Mr. Gautam was appearing in this matter. He's leading the case. It's actually the appeal. He's not well, madam. He's not well today.
Somebody should have made a mention.
Yes.
This is an old matter. You cannot be just kept pending like this. Time after time, some on one ground or the other, judgment is sought for.
It's a very short matter, my lord.
See, it's only indicated as a short matter. So, why did it?
Well, in brief, what happened, my lord? They filed a civil suit for claiming some unpaid bills, my lord. They're saying that they supplied some footballs or whatever to sports department. Total bill was 80 lakh rupees something. Decree was passed for 11 crore rupees, my lord. Now state government was the defendant, my lord. The state government, now to execute, they executed the money from our account, my lord, State Sports Council, who was not even a party in the suit, my lord.
Okay.
What the trial court does, my lord, she calls the bank manager, where our bank account is there, threatens the bank manager to transfer the money here. And the bank manager...
You have that on record?
That is on record, my lord. It's on record that the trial court summoned the bank manager because Mr. Gautam's client was state sports department, my lord. Knowing very well that there may not be money in their bank account, my lord, to execute, they executed from our account, my lord. Okay. And this was the central fund received for a different purpose, my lord. So out of 11 crore to 5 crore, 6 crore rupees is already withdrawn by them, my lord. So the remaining amount has been stayed by this honorable court. That money is
only towards the satisfaction of how many lakhs?
My lord, even that is, my lord, the total bill, the civil suit filed by them was for 80 lakh rupees something. Court executes 11 crore rupees. My lord. I was trying to calculate interest by which method 80 lakh can become 11 crore rupees. My lord. Mathematically is not possible. My lord.
I will not say anything more today, but since Mr. Gautam is not there.
No, Mr. Gautam, I'll argue the matter.
He's not there because that is again the other matter. Because
no, you don't adjourn on behalf of Mr. Gautam.
Just before the execution, my lord, both the departments were manned by one single individual, in two different capacities. In order to frustrate the execution proceeding, my lord, overnight the money was transferred to another account. Now they have come up with a plea that we were not even a party, so you cannot take out or you cannot execute the award or the decree, my lord, as against the account which is mine. And for the fact that I was not even a party. But the fact of the matter is, my lord, both the department, sports council as well as the department was manned by one single individual in a different capacity. So it was only, the money was transferred only for the purpose of frustrating the execution proceeding.
Lordship will also have to examine how whether 80 lakh rupees can become 11 crore rupees, my lord.
It was taken to appeal, my lord. Appeal also, my lord, it was in, the appeal was also dismissed. It was in our favor. Review was fine. Review again got dismissed. My lord, again the question now arises is whether, as against the order passed in an appeal, my lord, the revision will lie at all.
2 to 7.
2 to 7 is very confined, my lord.
Confined or not, 2 to 7, you can always extend your, or rather exercise your power in cases of this kind. When
This is the matter.
If there is any evidence, then that has to be
Your
taken up.
lordship can. But here, my lord, even the appeal, my lord, there has been a 2 concurrent finding by the 2 trial courts, 2 courts below. Now, whether, my lord, your lordship will interfere with the concurrent findings.
We'll look into the legal aspect of it. We'll look.
You can have it next week, my lord.
But
Mr. Gautam is unwell today.
Submission has been made on behalf of Mr. K.C. Gautam, learned counsel, appearing for the petitioner in a related case being CRP number 28 of 2016. The said counsel being indisposed on ground of personal difficulty. However, the parties are also going on to first see. And as such, accommodation is sought for in this case on this ground. Next, Dr. N. Musika appearing in a similar petition being CRP number 21 of 2026, which is tagged together with the said CRP number 28 of 2016, has however submitted that this case being a long pending one, it would be improper for the same to be prolonged, considering the issue in hand. Mr. S. Thapa, learned counsel for the appearing for the respondents in both the cases, in all fairness, has also submitted that it would be expedient for the matter to be disposed of as soon as possible. But for the prayer made. Accordingly, taking everything into consideration, the prayer for adjournment is allowed. However, it is made clear that no further adjournment will be accorded in this case. On submission made, this is matter after 1 week.
It will be 2 weeks more because Mr. Gautam is not well. He may take some time to recover, so I have it after 2 weeks more. Just to be on the safer side.
He is appearing as a state counsel. And the EG can come in his stead. The EG is the whatever the case may be, the EG is the first legal officer of the state. So he should take it upon himself. Mr. Prasad, you will inform the EG. If Mr. Gautam is not able to, or you get instruction from the department concerned, whatever the case may be, we will not delay this matter. Unless this matter for 2 weeks.
My lord, this is the respondent had to file that proceeding of the security force court by which the petitioner was dismissed from service. That is on order dated 20th July 2022, my lord.
Oh. Almost 9 months have passed by, Mr. Dr. Mazik.
But there's some difficulty in filing because the proceedings of they called me, my lord, to the department because this order was passed when I was your on. Because there's a procedure under the BSF rules, my lord, how to get a copy of the proceedings, my lord. After the trial is over, he has to apply for a set of copy, and it appears that in this case that the entire thing has been supplied to him.
What is the order? What is the order date?
My lord, order dated 20th July 2022, my lord. The
See, on
5th August,
on 5th August 2019, it was your own submission.
My submission. But otherwise, the copy of the proceedings, the file is with me, my lord. But there are restrictions on for him, my lord. I can place it with your lordship. So,
my lord,
but as far as my lord, without going into all these aspects, this is a case of desertion, my lord. He was appointed in BSF. He went for leave, my lord, and he rejoins after long period of time, my lord. And what he brings the doctor's certificate saying that he was suffering from diabetes. Now, my lord, diabetes cannot be a sufficient ground for not joining the, especially in the discipline force, my lord. If this is permitted, my lord, everybody will never come back, my lord.
Fine, since we have the record with you, then you deposit it with the court.
My lord,
I'll place it whenever the hearing takes place, my lord.
We'll hear it matter today.
My lord, that record by which, my lord, the petitioner has been dismissed based on that, and he is not entitled for that record, my lord.
My lord,
report of inquiry report.
Yes, my lord.
Court of inquiry report. That should have been given
Definitely,
to him.
my lord. By which the petitioner was dismissed. That's why the 5th August.
This is the security force court proceeding. Yeah. This is not a departmental inquiry.
Yeah, so there is no provision to.
This is like a court, my lord. The court, trial court, it is not that after conclusion of trial they will give entire copy to.
Even in a court, you know very well how court, functions. If the matter is over, disposed of, he is entitled.
Sentence awarded, my lord. After
Whatever.
that, he has to, if he wants any copy, he has to apply for that copy. There's a procedure for that.
Where's the procedure? Show us the.
This is the procedure.
Show us. Where's the procedure? Which says that he is not entitled to, but he can apply. If he applies, that means he is entitled to.
Yes, my lord.
Where is that provision?
Rule 129. But I'll just get the books, my lord. Rule 129 of the basic rules. Rules.
129 is otherwise. As for my lord, 129. Even the 129 says that I am entitled for. Then what is there to hide, my lord? Why they are even their submission, my lord?
Have you? Here it says that you have to apply. Have you applied?
My lord, the petitioner was a journalist. We have not. It's a finding, my lord.
Then you apply.
Yes, my lord. At this stage, that's why the submission was by the CGC at the last.
See, Dr. Mozika, you read Rule 29 firstly. He has to apply. Yes.
He has to apply. He has not applied.
So he has to let him apply.
Right.
Number one.
Right.
Number two, look at Rule 130. Even for security reason, it is not allowed to be given to him.
Right.
Even then, he is allowed to inspect. See, look at the provision. So there is no question of hide and seek here. After all, it is his liberty at stake. Or Dr. N. Muzika led CGSI, who has submitted that as directed by this court, the copies of the proceedings of the, what do they call it?
Security Force Court.
Security Force Court of the Border Security Force is produced before this court and may be handed over to the court as and when called for. However, as far as the prayer of the petitioner for inspection of the same, the learned JSGI has submitted that there is a clear provision under the rules, particularly Rule 129, which provides for supply of copies of such proceedings to the petitioner if the same is applied for. At this point, interjecting in the matter, the learned counsel for the petitioner has submitted that Admittedly, the petitioner has not yet applied for copies of the same and has made a prayer for the court that he may be allowed to apply for such copies in accordance with set rule 129. Though it is incumbent upon the petitioner to assert his rights, however, taking into account the issue in hand and for ends of justice, the court would allow the prayer of the petitioner at this juncture. The petitioner is to apply for these said copies and the respondent authority is to allow such application and to hand over any copies which are entitled to by the petitioner as far as the proceedings are concerned.
As per the rules, my lord, there are some restrictions are there, my lord.
As per the rules, as per the rules, the exercise is to be done within a period of 2 weeks. List this matter thereafter.
Item number 14.
Yes.
Lordship, I pray for a week's time, Lordship, in this matter.
Yes, who's appearing for?
I'm for appearing for 1, 2, and 3 respondent. 1, 2, and 3.
Any objection? Petitioner has sought for accommodation in this matter, to which the learned counsel for the respondent has no objection. Accordingly, the matter is adjourned. List is seen after 2 weeks.
Leave oblige, Your Lordship.
Item number 15.
Petition.
But this is that matter.
Recruitment matter?
My lord, that matter already heard only last, your lordship given the last opportunity to submit the written argument.
Oh.
That is the last, everything is from my side. I have given the written argument, judgments, everything is over. That post, sanction post, whether retrospectively after 17 years, they have not 20,
Yes,
more than 20
those
years.
recruitment rules.
Without permission. Recruitment rules not published.
Okay. But the matter may be concluded. I'll file it in some time. Within 1, 2 hours, I'll file it. That matter.
Within?
Today only, I'll file it.
My lord, only one thing, my lord. I have, on the other day, your lordship wanted that whether retrospective, that to assist this honorable court, I find out some judgment that retrospective effect when recruitment rules are there, not there, and even Government of India instruction. My lord, I'm only to assist this honorable court.
But Mr. Chanda, you have to give him a copy.
No, I'm giving, my lord, right now. Only that retrospective permission.
Then he may have to respond he may have to respond with counter authorities.
No, judgments only I have given, my lord.
Yes, exactly.
Judgment only to assist that your lordship wanted on the other day.
For example, I'm not saying that you're wrong or you're right. You have supplied the judgment file. There may be judgment which are, already overruled. For example, I'm not saying it's true, for which he may have counter, judgments or counter authority.
So he can include all these things in the.
That is what.
in the written argument.
Then you have to give, Lordship have to give me some more time, my lord.
1 week. You can do that. Please. This matter is a long pending matter. Mr. M. Chanda, learned counsel for the petitioner,
Additional list of books, my lord.
has submitted
Additional list.
an additional list of books with copies to the respondent, Union of India. Dr. N. Musica, learned TSGI, has submitted that he may be allowed to counter such the authorities cited in the said additional list of books by filing a comprehensive written argument in this matter, for which some time is sought for. As prayed for, the same is allowed. Let the written argument be filed definitely within the next date fix. List this matter after 1 week.
10 days, my lord.
My lord, can it be on 3rd of May, my lord? I have got some matter.
3rd of May is okay. I'll get
This is matter on 3rd May.
But otherwise, everything, hearing and everything is over, my lord.
Only for written argument.
Only for written argument.
I'll just give the bullet points, my lord.
Okay.
With my satisfaction.
Item number 16.
At 16, some other day. Bro, this is also old matter, my lord.
Same 3rd May.
My lord, actually here, my lord, only a short point is involved. 17% quota under the limited departmental examination in the grade of sub-inspector has not been introduced in Assam Rifle. In all other central paramilitary force, the same has been introduced. But 17% of limited departmental quota from rifleman to assistant commandant has been introduced by the Assam Rifle. But this to the grade of sub-inspector, that was not introduced. And after KK Dination and 6th Pay Commission recommendation, 1-to-1 parity must be there in between the central paramilitary forces. That is the short question involved here.
This matter was heard.
My lord, no.
No. 3rd May, my lord. We'll argue that.
On premier by the learned DSGI, list this matter on 3rd May. So 3rd May then?
My lord, can it be on 15th May, my lord? 3rd May, I have got another matter, my lord. Can it be on 15th May?
According to you?
15th May.
15 May.
Obliged, your lordship.
Mr. Chanda is getting away with everything.
No, my lord.
Getting all relief.
Getting relief?
No, my lord.
Getting time? What else?
It is your lordship, my lord.
Thank you.
Deeply obliged.
Item number 21.
This is a matter where I would have challenged the order of granting sanction by an authority which is not incompetent to do so.
Oh, that's CBI matter?
CBI matter. Very one simple line of argument, only on law point. Whether the court is correct in holding that the registrar of the university is the competent authority who could accord sanction.
Your Lordship, as per the last order, the petitioners were supposed to rectify. They were supposed
done,
to make
it's done.
some corrections.
It's done.
Lordship, we have not received the
Just
copy.
the first speech. Well, it's rectified. Only the certain typographical error was supposed to be corrected. I've done it in the court copy. Perhaps I forgot to give it to you. I'll give it to you. Then, my lord, next week we can hear this matter as well. Then.
Learned counsel for the petitioner has submitted that the rectification as directed the rectification to certain portion of the petition as was allowed by this court has been completed, and the matter is now ready for final hearing.
No.
On pyramid, how long?
1 week. 2 weeks, my lord, otherwise 2 weeks.
As per for this matter to 2 weeks.
Supplementary was this. Item number 4.
I think we have to go to the second half.
If it is kindly taken up on the coming Friday. I think my friend will also take time.
I have no objection on Friday, man.
Friday?
Friday,
On prayer made by the parties. This is matter on Friday. 21.
Lordship, giving your Lordship's indulgence, Lordship, in item number 6, Lordship had directed us to file the application seeking amendment within the course of the day. But Lordship, the difficulty is that the petitioners, they have retired and they are in Assam. That is one difficulty, Lordship. So I'm praying if that can be extended to 1 week, Lordship. We'll make endeavor to have filed by a week's time.
Oh, you can do it that was a submission to do it in the course of the day, but the matter has been fixed, I think, after a week. So you can do it, any day within that 1 week period. So as and when it comes up on the next date, if you can't do it, then we'll see.
Lordship.